Welcome to Courtroom Chronicles, where real cases unfold and justice gets tested in real time. Today's case, buckle up. Davon Wheeler walks into this courtroom already reeking of marijuana, and we're not talking a faint scent. The judge literally says he's getting high just by standing there. But that's just the smoke before the fire. Wheeler's not just facing a drug possession charge. This happened in a drug-free zone, which bumps it up to a Class A misdemeanor. That's up to a year in jail and a $4,000 fine. But plot twist, he's already out on bond for another offense, and guess what? He picks up a brand new charge while still on probation. And it doesn't stop there. A second defendant, Mr. East, walks in with a history of assault on a pregnant woman, no less than adds threats of violence to the mix. One courtroom, two men, multiple charges, and zero accountability. Or is there? Stay with us as we break down the rulings, reveal the legal landmines, and ask you the tough questions. Is the system doing enough to hold repeat offenders accountable, or are we just watching a revolving door of bad decisions? Let's dive in.
Davon Wheeler. Mr. Wheeler, you're charged with possession of marijuana. It's elevated to a Class A misdemeanor because it's in a drug-free zone. You're facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews in the state of Texas. If you cannot afford a lawyer, will be appointed to represent you. Does he reek of weed right now?
Yes, he does.
You reek so bad, I think I'm going to get high just from you standing in front of me. Okay, please.
Yes, Your Honor.
Okay, let's pause for a second. That wasn't just a figure of speech. The judge literally says he's getting high from the defendant's stench. That's not only embarrassing, it's revealing. Think about this. You're walking into court on a marijuana charge, and you show up smelling like the evidence. Either you don't take the system seriously, or you're so deep in the cycle you've stopped caring. Also, this isn't a regular drug possession charge, it's in a drug-free zone, which means higher stakes and tougher consequences. Real question for you guys: if someone walks into court smelling like the very drug they're charged with, that factor into sentencing? Or is that just a symptom of deeper issues? Let us know in the comments.
Oh my God.
24 officer at Teeny's Food Mart in Harris County, Texas, saw a defendant making hand-to-hand transactions with an unidentified male. Officer believed the hand-to-hand transaction to coincide with the possession and distribution of narcotics and/or marijuana. The defendant observed the officer and placed a clear plastic bag that contained a green leafy substance inside the front of his boxers. Wheeler turned around and attempted to flee the scene. Wheeler was advised a dog would be deployed and stopped when he heard the dog barking. Wheeler was detained without incident. The green leafy substance was retrieved from Wheeler's person. The green leafy substance weighed at 0.5 ounces. Teeny's Food Mart is in a drug-free zone.
No more outbursts, and you can be removed from the courtroom.
So, this gentleman here was on bond for a case, and he now picked up a new case. Did he have the bond conditions to not pick up any new cases? Wheeler. We tell you not to pick up any new cases while you're on bond.
And here we go. This is where the legal system tightens its grip. Wheeler was explicitly told not to pick up any new charges while out on bond. But what happens? 5 days later, boom, criminal trespass. This is where legal consequences pile up fast. When you violate bond conditions, judges don't play around. Your PR bond gets yanked, and you're headed back to jail, no questions asked. This moment matters because it's about trust. The court gave him freedom, and he repaid it with another arrest. Here's the breakdown. Marijuana possession in a drug-free zone, criminal trespass, violation of bond conditions, that's 3 strikes in less than a week. Do you think the judge should revoke bond completely or give him another shot?
Otherwise, the PR bond that you get is revoked and you get put into jail. You were on bond for criminal trespass. You've now picked up another case, and also you're here and you reek of weed so bad, you must have just stopped smoking right now.
Judge, actually, it's the other way around. He was on bond for the PON. That arrest was out of April 24th, 2024. And
Oh, I see.
He picked up trespass April 24th.
Okay, so we're here on, I thought we were here on the weed case. So we're here on the trespass then.
Judge, because so before he approached this court on the marijuana case, he has since picked up the trespass case. He was on bond for the marijuana case before he approached here and picked up the trespass.
So, I'm sorry, so he's charged with the criminal trespass here, not the weed.
Oh,
Both, right, but the reason he's in front of me now is for a criminal trespass, because that's the new case stuff.
he's never approached, he's never been here on the possession of marijuana case. That happened April 24th. And on April 29th, he picked up the criminal trespass. He never approached this court on either case.
I have here that he signed conditions of bond on 4/24, not to pick up any new cases, and now, 5 days later, he's picked up a criminal trespass. I mean, am I wrong?
Oh, you're right, yes, April 25th,
No.
it has judge's signature, yeah. It says, the defendant shall commit no crime and shall not engage in conduct that can result in his or her arrest.
It's not looking good for you, Mr. Wheeler. It's Altamirano, right?
Yes, sir.
Welcome back. Mr. Wheeler, I'm revoking your bond and I'm keeping you with me. He goes with you. Can you please appoint Mr. Wheeler a lawyer, and then we will talk about what's going to happen, please?
Let's not gloss over this. Wheeler was already on deferred adjudication for assaulting a pregnant woman, and not just any woman, his sister. Now he's back in court, and the judge makes it clear, no PR bond this time. Why? Because this isn't just about new charges, it's about a pattern of violence. Deferred adjudication is essentially a second chance, a way to avoid conviction if you stay clean. But Wheeler blew that. And once violence enters the picture, especially against a vulnerable person, courts lose patience fast. Viewer, check-in: should assault against a pregnant person carry harsher long-term consequences, or does everyone deserve a second chance of repeat offenders?
He's got a $5,000 bond. They did not grant him a PR bond, mostly because he's on deferred out of the 232nd District Court for assault on a pregnant person. That's a different complainant. The complainant there was his sister. So.
Hold on, you want to bring him out?
Sure.
Stephen, do you mind bringing someone out, please? Yes, sir.
I was just giving you a little preliminary before you brought him
I
out.
want him to hear it.
I understand. But he went to probable cause court. They denied a PR bond. He does have family here, and he is employed. And we're asking the court either for a bond reduction or for a PR bond. He's been on deferred since January of last year.
Manuel?
And the assistant district attorney's already notified them that he has this case. We're not sure whether or not they're going to file a motion to adjudicate or not, or take any action.
Hey, he's in the order for the wake up.
Yes, sir, no, sir.
Yes, sir.
To East,
Yes, sir.
how's jail?
To be honest with you, it's not nice.
Great.
It's not nice at all. And
It makes me very, very happy because I hope it's one of the most miserable, rotten experiences that you ever had.
It is, sir. And I wish to never see it again.
The problem is you keep doing things to land you in there.
Yes, sir. And I will try my best to do more to not end up back in here, sir. I promise.
The road to
This moment, right here, powerful. The judge isn't just handing out consequences, he's trying to reach Mr. East. You can feel the weight in his voice when he says, I hope it's the most miserable, rotten experience you've ever had. And then, in the same breath, offers him a lifeline. This is the line between justice and rehabilitation, and the court is clearly trying both. But the big question is, will it work? We've heard these promises before. I'll never go back. I'll change. But talk is cheap. Your take. Should emotional appeals from judges carry more weight than cold, hard sentencing? Or are we too far past empathy when threats have already been made?
hell is paved with good intentions, Mr. East.
No, sir.
You're on a very serious probation for assault of a pregnant person. And now, picked up terroristic threat. You're now facing another year in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, sir.
You have the right to have an attorney present. You can inform one will be appointed to you. I don't even know what happened to your case. All I know is that you're on a serious probation,
Yes, sir.
and now you've picked up another case. So let's see what happens
Yes, sir.
and whether you deserve to be let out.
Yes, sir.
Please.
On April 29, 2024, in Harris County, Texas, the defendant threatened to kill the complainant and the child that they shared together. Complainant felt in fear and pepper sprayed the defendant while on the phone with the 911. Defendant admitted to the threat, stating it was out of anger.
What do you think? What other does he have any other prior criminal history from anywhere else? Juvenile?
So, Judge, his priors are all in county. He has assault a pregnant person that he's on probation for against his sister, and an AFM, which was, it looks like it was.
So he has another assault.
He has an AFM from
22.
I think it was the same.
It was refiled. So it was an AFM that was refiled to assault a pregnant person.
That was the sister. The complaint was his sister.
Correct.
Not the
Complainant on that
same
case was his sister, and the complainant in this case is the child of, or the mother of
his child. You're not compensating baby mama.
Yeah, try not to. Did you make it?
Mr. East, what do you do with your life now?
Right now, I'm working at a thrift store. I'm not getting paid that much, but I'm getting paid just enough to take care of the child. And right now,
How are you going to take care of a child? You can't even take care of yourself, Mr. East.
I'm still learning. This is my first child, Your Honor. This is my first child, Your Honor, and
You know, the problem is that with all
This is one of the most impactful moments in the entire hearing. The judge lays it out. If your child sees you threaten mom, what do you think they'll grow up to do? And that's the real tragedy here, the generational effect of violence. Mr. East claims he'd never hurt the mother of his child, but moments earlier, he admitted to threatening her. This isn't about what he thinks he'd never do, it's about what he's already done. You can feel the judge pleading for a better future, not just for East, but for the child caught in the middle. What do you think? Should parenting, the ability factor into bail or sentencing decisions when children are exposed to domestic threats? Tell us your thoughts.
the anger that you have, if a child sees it, what are they going to do?
they're gonna feed off that same energy, sir.
Right.
And
They're going to be just like you. If
thank
they see you beat mama, threaten to kill mom, what are they going to do?
you, same thing, but I would never touch my mother, my child's mother. I would never. I would never.
Patient for the very same thing, Mr. East.
I understand, sir.
I don't know, Carl. I don't know. You know, I'm not.
He's a lifelong resident of Harris County, Your Honor. He's not a flight risk.
I'm not. My concern is the public.
I understand. And the conditions are right now, he does have a place to stay. He lives on Tidwell. The mother of his child lives at a different location, and he orders are here for him to not have any contact with either with her, the complaining witness.
What was the tipping point here? Why did he get so angry?
4 o'clock in the morning.
4 o'clock in the morning.
I had got a phone call from a girlfriend of mine because she was having some problems of her own, but I was sleeping and I didn't hear her phone call or her texts. So while I was holding the baby, I asked her.
4 in the morning.
4 in the morning.
Yes, sir.
I believe he responded to some text from another female judge, and that's what caused the altercation between him and his mother of his child, which is understandable. We've talked about this. But he did not assault her, and as a matter of fact, he was pepper sprayed himself during the course of the altercation after he made the threat. He admitted to the officers that he made the threat out of anger and had no intention of following through on it. He is gainfully employed. He just started his job last week. Hopefully he still hasn't. He hasn't been bond forfeited for. He has not failed to appear in court. He's not a flight risk.
I'll make you a deal, Mr. East.
Yes, sir.
The only way, because I think that everybody should be given a chance.
Yes, sir.
You weren't given a chance here. You're on probation, which is a serious
charge.
What I want to see, though, is you proactively addressing your anger.
Yes, sir.
The only way I will let you out is if you take it upon yourself 3 times a week to do anger management classes somehow, some way. And I want proof on a written piece of paper that you're actually doing some kind of anger management.
Yes, sir.
3 times a week.
Can we make it 4 times a week? I'm sorry to interrupt you, Judge.
3 is sufficient.
You need to do something that's realistic.
Yes, sir.
Don't overkill because you're setting yourself up to fail.
Yes, sir.
All I want is you to address it. And the way that I can do that is by dangling a jailhouse key in front of you. So you hold the keys to the jail. I want you to do 3 anger management classes a week. And I want you to bring it proof to me every Monday.
This is where things get interesting. Instead of jail, the judge hands Mr. East a chance at redemption, but with strings attached. He must attend anger management classes 3 times a week and bring physical proof every Monday. Miss 1 class, back to jail. This is what's called a conditional release, and it's becoming more common in cases like this. It offers structure but also tests whether the defendant truly wants to change, and the judge says it flat out, you hold the keys to the jail. That's not just metaphor, that's personal responsibility in legal form. So we ask you, is this the right approach, or should the system be tougher on those with violent pasts?
That you've done 3 classes a week.
Yes, sir.
And the first time you falter, I will yank the bond and I'm going to put you in jail. You now know that you have no one to bond you out. So if you go to jail, you will be stuck like Chuck.
Yes, sir.
You understand?
Yes, sir, I understand.
Give you this one and only chance.
Yes, sir.
Make me proud. Don't fail me.
Yes, sir.
So we need to find some kind of anger management class. I'm sure that there are free ones. It is up to you to find it. It's not up to Carl. It's not up to your girlfriend. Not up to you.
Yes, sir.
You.
Yes, sir.
And I want you here every Monday with proof in hand that you've done the anger management classes.
Yes, sir.
3 week. No dope, no alcohol. Carl, I'd like to know who the extramarital person is, and we need to cut that off so that there are no reasons for her to get upset or you.
Yes,
You
sir.
focus on one and you focus on that child.
Yes, sir.
Understand?
Yes, sir.
This is the only chance you're going to get from me. You will not get another one. If you don't believe me, look around.
I believe you, Your Honor. I believe you, Your Honor.
Jeez, make me proud.
Yes, sir.
Judge, do you want him to have no contact with the complaining witness, or do you
I would
want him?
say until things are better, yeah, no contact and no weapons.
Present time.
Yeah. With this one and the other probation case as well. Yeah.
Understand, but
Yeah.
those probation case, the complainant there was his sister. You want no contact with her also?
Yeah.
Okay, fine. Just want to make sure he,
It's probably already a condition of felony probation. That's
well, I understand. I just want to make sure that he understands while he's here.
It's already stated that I shouldn't have contact with Malaysia Triplet or have any.
Stop. You know what's expected of you.
Yes, sir.
That's the only thing that matters.
Yes, sir. Thank you, Your Honor.
Thank you, Your Honor.
Thanks, Carl.
On the bond into the PR or reinstatement or?
Not the PR, because he never got a bond
I
whatsoever.
wanted to make sure.
Yeah.
Come on.
Thank you, Judge.
Oh, thanks.
Last name already done.
Where have you been? Do I know you?
What a roller coaster in today's courtroom showdown. We saw two defendants facing the weight of their pasts and the consequences of their choices. Davon Wheeler, charged with marijuana possession in a drug-free zone, violated bond conditions and had his PR bond revoked on the spot. Meanwhile, Mr. East, already on probation for assault, returned after making a violent threat. But instead of jail, the judge took a risk, giving him one final shot through strict anger management terms. It's a powerful reminder that justice isn't just about punishment, it's about change, but change comes with accountability. So, what do you think? Did the court go to ease, or did they strike the right balance between compassion and control? Drop your take in the comments. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll be back next time with more cases, more consequences, and more courtroom drama. See you then.